We're alive. We're back in Senate Judiciary, picking up the miscellaneous bill. 26, we'll get the House lists and floor leaders.
Good morning. For the record, Michelle Powell's Office of Legislative Counsel, and everybody should have a copy of draft 6.2 for H 937, individual instances of amendments. There are some new things in here that the chair asked me to add for your consideration, and I will go through those, and then others you've already seen before, so I'll just note them and move on. So looking at page 1 on the first instance of amendment, this was something that was brought to the chair's attention by Willa Farrell, to the diversion program. And this is amending the section. There's already a section in miscellaneous as it came over from the House. And so we'll be amending that section a little bit further. And the short answer is, and I think you probably want to hear from Willow or somebody from the AG's office, is that so last year the General Assembly passed Act 45, an act relating to expanding the Youth Substance Awareness Safety Program. So I don't know if y'all remember that one, but it was a pretty substantial rewrite of the statute with regard to like possession of underage possession of alcohol or cannabis or using those sorts of things, and sending the underage folks to the program. I still want to call it TASK because that's what it used to be, 20 years ago. I think when Aaron first named it, and we need a good acronym for this one. One of the things that the General Assembly did is it added as an offense for which you could get referred to diversion. It is underage driving a vehicle and having a 0.02 for VAC. And that one offense would result in an immediate suspension of the operator's license. There are other things in that statute that would result in a suspension of a driver's license, but it's only if for the other offenses that are not the driving related ones, if that you failed to contact the diversion board or didn't successfully complete the diversion board, then there is a penalty of a temporary license suspension. But my understanding from Willa was that it was the intention originally in Act 45 was that that one offense under there for the 0.02, in addition to being referred to the program, you would get a temporary license suspension immediately. And so there's some language that was also added in that act, and you'll see that in your amendment in subsection D, starting on line 8. And it talks about, on behalf of the Commissioner of Motor Vehicles, law enforcement officer who issues a notice of violation, so it's providing the youth with a ticket at that time, shall also serve a notice of suspension of their operator's license. And so Willa contacted the chair and said, I think that without this change on line 11, making it clear that you're referring back to that 0.02 offense, it makes it sound like there's an automatic suspension of your driver's license for any of those other, so like being caught with beer or something like that, but not in motor vehicle. And so the way to address that is just to make the language clear here that with regard to this immediate suspension, which means at the time of ticketing, that it only applies to the 0.02 offense. So this was something that Ben had worked on last year, so I wasn't here for terms of remembering what your intent was, but that was Willa's take on it, was that, and it seems to make sense with the rest of that statute and the way it's laid out. So to me, if that's the case, then I would look at this as really just a technical amendment clarifying that the intent of subsection D really only applies to the 0.02 offense.
And I do think it also kind of gets to the question that Senator Maddox had raised a while back regarding, how are you going to suspend the license of a 12-year-old that who doesn't have a license? And so I can see how that makes a bit more sense to have it applied to that, only the 0.02 violation.
Unless, of course, a 12-year-old was driving a car.
Well, they still don't have a license,
That's my point.
so.
You still can't suspend their non-existent license.
Any issues with this change? Any questions?
Great. So, second instance of amendment, we've already talked about, and that is removing, this is on page 2, and that's removing that section that came over from the House around establishing the minimum age of 12, and for possession of tobacco. And S-189 is the bill that passed out and that Senator Bohosky drew our attention to. Human Services is planning to get that voted out this week. And the 12 years of age is part of the whole discussion there. They're looking at perhaps like if the Senate might have taken out all the penalties, and I think the House is looking at perhaps, not don't hold me to it, because who knows what the next couple of days could bring, is looking at just having a very minor penalty or no monetary penalty, but sending them to a smoking cessation program. If they have any kind of offense there, that it be for like fake ID and things like that. So I'm not sure where that's all going to land, but the issue of establishing a minimum age is part of the whole mix of that one. And the reason why I'm suggesting that you don't have it in here is because they overhauled that statutory section so completely that if you make the change here, lots of times, like if two bills are going and they are passing kind of in similar time, you can just true them up after passage, but it doesn't, the language doesn't quite line up that way. So I think that policy should be even. And then it'll come back here. And if it doesn't have the minimum age of 12 in S-189, and you think it's appropriate, then if you can look at adding that into that bill. And Jen and I are in contact about this, so we're keeping track of the issue.
Any questions, comments?
So the third instance of amendment, this is on line 7 on page 2. This is fixing a typo in section 5. And this is the section dealing with the renewal of a family court judgment. And so it's just changing the word affirmation to affirmative. So the fourth instance of amendment is where you're adding new sections. So these are all new sections that are coming from the Senate that were not part of the House bill. And I'm going to skip, I'm just kind of identifying but gloss over the sections that Hillary has been working with you on, because there's a few of those. The first one is section 40A, and this is a section that clarifies that victims can opt out of any notification or other services that DOC is required to provide to victims. And she went through that language already with you last week, and you guys were okay with that language, so that's what that is. Moving on to page 3, line 3, section 40B, this is your home and land improvement fraud language. We've already gone over. Page 4, section 40C. This is the little technical tweak to the 1983 action bill, HB 49 that you passed, just clarifying that that the Vermont State Court Claims Act applies, and just a little clarification there. Page 5, section 40B, and I realize you have legal aid in here and they can address this more fully, but they had contacted the chair looking at doing some small tweaks. There was a bill that had been introduced in the House that is still sitting there, and it would be making tweaks to the tenant representation pilot program. So that was originally enacted in 2023, and it was to be a 2-year pilot. But, you know, as is common now, it had some language in there is that the pilot was contingent upon funding. That funding did not happen for FY24, but did occur in FY25, but it resulted in the program starting, later, obviously, and it's operating now. And so what you have in section 40D are just some tweaks to extend the pilot program statewide. So you'll see right now, it's just Lamoille and West County. So it's extending it statewide. And then if you turn onto page 6, there's just some changes in subsection B with regard to the reporting dates because it started later.
And Michelle, this doesn't appropriate any new funds, right? This is
Correct. I'll get to the funding here, down at section 40B. Sorry.
Michelle, so I am assuming that November 30th, 2025, we already got a report
Yeah,
and it's just screwing up with what has to happen.
I understand. So section 40E, and this is the language that came from JFO, and it was kind of something that happened last night, and we didn't really get to connect that much this morning. If you need a deeper explanation of how the money is flowing, I would say maybe you have someone from JFO give you a little quick rundown of that. But this is how they said, is that basically amending the 24 act. Basically, this is, I think this is the budget for 24, the appropriation for this program, and then just adding this carry forward language.
I know maybe we have legal aid in the room. Is there a estimate of what is left of the 1,000,045?
So for the record, Andrea Smith, Policy Director for Vermont Legal Aid. So the total amount was 1.025 million for the 2-year pilot. And right now we're just asking for a slight language change for us to have the ability to represent more people outside of the Lamoille and Windsor counties.
Understood. I'm just wondering, is that entire sum left or
No,
what's
it's not. But right now we're not allowed to change our grant contract with AHS without this legislative language change.
understood? I'm just asking how much is left.
I don't know, but I'm happy to follow up with you on that. Yeah.
Then the last two, sections 40F and G are your HRC language that you've been working on with Hillary. And so I will, unless you have questions about anything else in here, I'll pass it off to Hillary so she can walk you through the changes that are highlighted that she's made since the last time you looked at this language. And then if we have time, I'll rejoin you and I can walk you through the RFA language. I can do it from here, John, unless you'd like to watch these. Come on up. All right.
Showcase.
All right, for the record, Hillary Tedder Eames, Office of Legislative Counsel. We have one change to the Human Rights Commission investigative report disclosure language we talked about last week, I think at this point, last Thursday. So these sections will be section 40F and 40G of the Miscellaneous Judiciary. The changes that are made are on page 8, lines 10 through 15. So as drafted, this required the commission to make any investigative report from an HRC initiated complaint public, to make available to the public. And there was discussion last week about whether that meant in response to a Public Records Act request or also a kind of proactive disclosure by posting on the website. And the request was to be more specific in that language and specify that it would not be confidential, so it would be produced in response to a Public Records Act request, but that it not be proactively disclosed. So this language will require the Human Rights Commission to produce an investigative report from an HRC initiated complaint in response to a Public Records Act request, but they are not allowed to proactively disclose it from the website. So on page 8, lines 10 through 15, for any complaint initiated pursuant to subsection 4554B of this title, and that means when a commission employee initiates it, any resulting investigative report shall not be confidential. That's the Public Records Act request key language, to produce it. After the commission has issued a final determination and after the parties have been notified of the commission's determination, except that the commission shall not proactively disclose any report and shall not disclose the same categories of information that we had discussed before. Any questions about that language or that change?
Yeah, so I understand proactive is going to mean that they can't initiate disclosure of themselves.
Yes.
Only, someone from the outside can ask that. Right.
Correct. In the kind of FOIA and Public Records Act world, proactively disclose is captured that idea from the website or otherwise making it available without some kind of list. I think, as I mentioned a little bit previously, I think in future, this section was not drafted or was drafted before. We had a more consistent approach to drafting Public Records Act related language. So it might not be this legislative judiciary, but at some point in the future, there'll be a chance to make sure that the way this section addresses Public Records Act related confidentiality is consistent with the way that we've now come to do with other statutes. So a fun project.
Thank you. Any other questions? Okay. Thank you.
All right. Shall you're back up. All right.
I need a second here to pull up the bill is introduced in the House with regard to the protection orders. Since you don't have that in front of you. And I'll share on the screen. Okay, so
While you're doing that, Michelle, can you remind me if this is also the same language or similar language that M. McManus had suggested? No, that's
totally
not-
doesn't. That had to do with Chen's
Right.
kids being taken into custody. Six, 2 minutes. So, you'll recall, and Charlie already talked to you a little bit about this, I think last week or the week before. And this is related to protection orders under Title 15. So we're working in the domestic relations title. So we're working with that. It's between family members or what is household members, so dating relationships, things like that. So you see so you have section 1, 15 VSA 1103, and so this is relating to final orders. So remember, you have the ability to have a temporary order, an emergency order that's an ex parte order, but then within a certain number of days, you have to have a hearing on the final order. Moving on to the first change, as you'll see in subsection C. So the court shall make orders it deems necessary to protect the plaintiff's children, or vote. If the court finds the defendant has abused the plaintiff, and it's not changing anything with regard to the finding of abuse and the definition of abuse, so I'm just gonna bypass that for now unless you want me to go back to that. Is that there's been a finding that the defendant abused the plaintiff, and one, there's a danger of future abuse, or the defendant is currently incarcerated and has been convicted of one of those following offenses. So the first suggested change by the network is to also include if the defendant is currently under supervision of the Department of Corrections. So this would be, so let's say someone had a domestic assault conviction. Maybe they did 30 days incarcerated and they're doing the remainder of their sentence in the community on a probationary sentence, right? So that would mean that maybe so that they could automatically qualify under B if the person is out of the community. So just a policy decision for you. There's no particular legal issues or anything like that. It's just looking at the standard for being able to issue the order. So the next one is that you'll see in subdivision 2 there, the order may include the following. And so if you'll recall, working in the statute, there's just a laundry list of things that are options for the court, right? And they can pick and choose what those various options may be according to each circumstance, right? So I'm gonna look down at the new language. So I want to highlight something that's in current law, and then we'll look at that compared to the new provision that's added in these proposals. So in subsection E, one of the options for the court is that if the court finds the defendant has a duty to support the plaintiff and order that the defendant pay the plaintiff's living expenses for a fixed period of time not to exceed 3 months. Subdivision F is different in that it's an order that the defendant continue to pay household bills for which the defendant was responsible at the time the plaintiff requested the order. And then they would do it for a fixed period of time. So when you're thinking about how these both play out, and I'm sure Charlie can give you better examples because these are recommendations that are coming from the clinic that they work with, is that under F, it would be more of a circumstance. Let's say if my partner and I, somebody pays mortgage, somebody else pays the light and the water bill kind of a thing, is that if the defendant was responsible for, let's say, all the utilities and I paid the mortgage, right, is that the court could, under the subdivision F, without having to make a finding up in E, that the defendant has a duty to support the plaintiff. So maybe there is no duty for ongoing continued support. But that the fact that perhaps the defendant had to vacate the community, shared household, maybe the defendant is like, well, I'm not living there. I'm not going to continue paying the utilities. And that might put the plaintiff in a situation where they are jeopardized because the utilities are not being paid. So again, it's discretionary for the court. And it's just a policy choice for this committee to decide whether or not they want to give that option to the court.
And was it this section or the previous one or both that the House had some disagreement over?
They really didn't talk. It just had one hearing, and so they didn't spend a lot of time on it. My recollection was, I think most of the discussion was around this particular provision rather than the earlier provision, around extending it to the supervised period. And I think my recollection was there was just a lot of discussion around kind of these different types of scenarios, trying to think through who was responsible for what bills and what kind of how this would play out. And I think they just didn't really have enough time on this particular one to really vet. So
Yeah, I could see that. That was one of my it's coming back to me now when I first looked at this, if this would be this particular subsection F.
Yeah, there's like one decision point on the other one. This one you can kind of see because if there's differences, if you look between E and F, E requires that the court has to find that the defendant has a duty to support. F, there's no requirement that there's a duty to support. And there is a limitation on the fixed period of time for E, and there is not for F. So you could construct that however you want, however you want, it doesn't have to stay like this, but there's a few more little kind of policy decision points that are contained in this material.
Yeah, it's less for me an issue about time, but more of an issue about whether or not this is something that should go into the miscellaneous bill. This particular subsection have that might have a hesitation. Senator Bose, do you have a question?
So I do. So E is existing law.
Correct.
And applies when. So I guess I'm trying, because I'm trying to understand. How are E and F different? Like they seem to be saying kind of the same thing.
They are
in different
similar,
ways.
I think. So again, if you look at E, if the court finds the defendant has a duty to support the plaintiff, so the question is, okay, so what goes into that determination for the court, right? So if you were, Judge Zone was here, could talk to you about this is what courts typically look at, things like that. I can take a look at the case law, see if there's much discussion in that, but probably Judge Zone would be the best person to talk to you about the factors that the court considers in making that determination. That determination is not required in order for the court to order the defendant to pay, to continue making payments like they were making the payments prior to the plaintiff filing for the RFA, right? So it's like, and you can imagine, you have two parties who are in conflict, they're sharing bills and sharing household expenses, and then somebody files an RFA. Somebody's like, I'm not getting anything, especially if I can't live there, right? And then that may cause a lot of disruption for the plaintiff and her children living in the house who may then face with utilities being turned off or other types of party disasters, things like that.
Right. Yeah, I guess, and maybe I just need to look at the F almost seems like just a rewording of E. And so I guess, and maybe Charlie is the better person to hear from. I'm trying to understand what F would accomplish that E can't already accomplish. But
I think that, again, the suggestion came from them, and so I think probably she can fill in a lot of that and tell you why they think this.
So one sec. Charlie, do you want a quick overview of your thoughts on specifically having that house?
I'm happy to. So Charlie Glusserman, Policy Director at the Vermont Network Against Domestic and Sexual Violence. And I would say the common principle between E and F is part of why we felt this might be an appropriate ask for the miscellaneous judiciary bill. That language in E was added to the statute in 1993. So before I existed on this earth. And the relationships and financial relationships between plaintiff and defendant have changed a lot since that time. And so what we are often seeing in our legal clinic is exactly what we're trying to address in F, where people have existing financial arrangements to split bills that then when an RFA is filed for the protection of the plaintiff in retaliation, the defendant says, I'm not paying those bills anymore, you're on your own. And so that could be, a residence where plaintiff and their children are residing and they lose their utilities because they don't have the income there to cover those expenses. So, that is a act that is, it's a wielding of power that is trying to force a plaintiff into a situation where they continue to be unsafe despite trying to seek safety with an RFA.
Senator Meadows, that's hand over first. That's one. stick to the order, but Senator Madison and Senator Bruce.
Yeah, well, I will just say, I think it's covered by E, that dot, but the 3 months if it goes on for over 3 months, can the plaintiff go back and say, hey, I need this re-upped for another 3 months? Is it a hard stop at 3 or can it be extended? It might be a question.
So, you wouldn't do that through this process, like if let's say if they shared children together, right? And remember we expanded, the ways in which you can be identified as a legal parent in the last few
Yeah.
years, right? So it might just not be your biological child, but you've been raising this child in your house for a number of years, and such. Is that you're gonna be initiating a family division action in those particular cases. And so in terms of support for the children or support for you, so like if you were staying home with the kids or maybe had a little part-time job, but your partner was the full-time income really for the household, is that you would then file something in family division for proposal for maintenance of economic or child support and go that route rather than doing it with this type of action.
But solidifies even if like E gives you 3 months and then you're gonna go take that route. I don't know why we need F. Because I think F is just E without the time limit.
And I feel the same way. I'm just wondering, Charlie, is it an attempt to provide greater specificity to the phrase duty to support? Is that, have you found that to be too vague in court? Or, because it seems to me, if I'm the judge, duty to support and living expenses would include household bill. So,
So the feedback we heard from our legal clinic is that this piece around splitting household bills as they were split prior to an RFA is not something that is ordered nearly enough as it's needed in court right now. So the goal here was to be very clear in saying in the court, you have discretion to order this, and you don't necessarily need to find a duty of spousal support in order to say you need to maintain financial arrangements prior to the RFA. Again, this is at the full discretion of the court about whether to order this or not, but just being very specific, that is an option for the court.
So I think I do understand now. This is something the court could already do, and this is sort of clarification because it's not necessarily happening that they should consider this. And the sort of duty of support is sort of a spousal thing. And I imagine much like most of the country, there are more instances of domestic partnerships that may not be marriages. So this is sort of updating and being clear to the court what he means. Okay, that makes a lot more sense to me. And now I understand sort of why it is kind of miscellaneous. It's not really clarification. Thank you.
Well, there's the difference between the 3 months versus the indefinite use, which is less technical. That's, go ahead.
If the committee would feel more comfortable limiting it to 3 months, that's something that we would be fine with.
Isn't it on the defense attorney to ask the court for that? And then if the court finds it, they would still have to request it in F. I just don't see how they're different without one has 3 months, one doesn't have 3 months. If the court finds, I'd imagine the defense attorney is going to say, hey, we need help paying the living expenses. And then they would find that to be true, order it, versus F is saying, in order after the plaintiff requested it. They'd be asking an E anyway for that. Isn't it on the attorney to ask for that? The plaintiffs are.
In the interest of time, I think it's best to put a pin in that and actually go back to the earlier section we talked about. I think there are a lot of questions about that, but I think there could be, the earlier section could be something.
I feel like it would be great if E and F were rewritten and that's into community. Because I feel like now it's attempting to situate itself around that provision in a way that's a little bit repetitive, and a new version of both would allow it to do a more efficient.
That makes sense to me. I mean, I know we do it all over the place where we sort of say like, hey, this is kind of what we meant, but you're not really doing that, so we're gonna clarify.
Right.
Which is why I do with the addition of keeping it at 3 months, see it, that's kind of a technical change, but I do see your point, like rather than having both, it might create less confusion to just replace.
I'm happy to connect with our legal clinic who recommended these changes and Michelle, so we can investment.
That would be good, and especially if you can get Jack Villani's input that way. Thank you. Remind me again, this section, under the supervision of the DOC, what is this changing again? So it's going from incarcerated to somebody's on probation.
You know, I'm just actually wondering, should that be incarcerated or under supervision or?
I think under supervision, would that also capture incarceration?
Okay, all right.
Or would it have to
So
be
this is the standard, right? So the court, there has to be a standard, right, in order for the court to issue. So one, they have to first find that the defendant abused the plaintiff according to the definitions for abuse, right? So first finding. And then the second finding is that there's a danger of future abuse. Or you don't have to find that there's a danger of future abuse if the defendant right now is currently incarcerated at the time that he's doing the order for murder, attempted murder, kidnapping, domestic assault, aggravated domestic assault. So all the things that like, so if you think about the offenses for which someone may be incarcerated for harming the plaintiff, right? And so what this is doing is expanding it so that it would include not just if the person is locked up, but if there's certain part of their sentence or all of their sentence in the community. So basically, so then there would just have to be a finding that the defendant abused the plaintiff and the defendant at the time of the issuing of the final order is under supervision for one of these person-to-person offenses.
And those are all pretty serious offenses.
Correct.
So, so there was an initial finding that there was abuse.
There was abuse.
And that the person was then convicted of one of those
Right.
serious offenses, then RFA could be imposed on that defendant.
Correct.
I'd be fine with that.
Well, I mean, it sounds like currently by law, it would be opposable if the person was in jail, but not, they were serving their sentence in the community. And it feels to me it's almost more important to be able to oppose it if they're out.
Right.
I think that makes sense.
Right. And so, correct. And so, it may be, you're assuming if the person's going to have conditions if they're being supervised in a community, but the RFA provides an additional layer of protection in terms of being able to, certain criteria around staying away from the person, perhaps not no contact, things like that. That can be enforced through the family division.
Any issues or questions about this change? You good with that? Yeah. Okay. All right. Do you see any issues with
I
this?
do not.
Okay. All right. I'd be good with adding this change and just this change regarding the supervision of TSC to the next round of the miscellaneous. So,
Okay, Bob, I just have a question. Is there an ending date on relief, just sort of final relief?
Yes.
I can think of, so they have to file this continuously? after
Yes,
that?
they would have to go back to court and ask for it to be extended.
anything else with the miscellaneous bill?
Just E and F.
Not that I can think of, but if you hold every day, something new, so.
Toss in there.
Well,
And I'm happy if you'd like, you know, I'm happy to work with Charlie and Judge Zone and see, I totally understand what you mean. You know, think eventually there may be, the solution to this is, I would agree, combining, updating that language from the early nineties and looking at that, whether or not that can really be fully vetted in a way that we feel comfortable with, that you're not losing anything and you're getting directly at the conduct that you want to sweeten and make clear. You know, we'll see what we come up with or whether or not we both feel it's worth it.
and would you be able? Actually, Emery, we don't have anything for tomorrow at 9 a.m. And I would you be able to do it tomorrow for, okay. So we'll come back to the miscellaneous bill first thing tomorrow morning. We have 3 bills that we've already agreed on. We can vote those out quickly at around 10 once we have a full committee. Then we'll have 772, the new draft. I think that will wrap up. I think that will wrap up everything. Not missing anything.
Not that I know of. So for the next draft, I will include
That's all.
this first amendment on the RFAs. And if we have something by 9 a.m. tomorrow, I'll bring that as just kind of standalone people to be considered.
That would include all our work. Well, we'll have minutes and offices and Senator Matos.
Yes, I heard this morning.
179.
Disclaimer.
Yes. How are we feeling about adding the word minor?
Made some phone calls just to check in, but I think I'll be okay with it.
So that'll be on the floor today. Just want to mention that. And then 298 we'll pass over for today. And we'll do a bit more digging.